The Voting Rights Act was passed in 1965, and if you remember your history, in 1965 there were terrible problems with race relations and allowing minorities to vote in certain states, especially the southern states, Mississippi, Alabama, Louisiana, Texas, Georgia. And what Congress did at the time, it was right after the civil rights murders in Mississippi. It was spurred. President Johnson was in office at the time, and he said, we just can't have this anymore. We can't live like this as a country. And he proposed the Voting Rights Act, and it passed a very short time thereafter in 1965. And what it did, there was one certain section of the Voting Rights Act, Section 5 of the Voting Rights Act, that applied to states that had a history of discriminating against minorities. And Mississippi was one of those states. And what Section 5 said was that if one of these states that have a history of violating minority rights passes any law that has anything to deal with changing the voting laws of that state, you have to actually submit it to the Justice Department in Washington, D.C., and let us approve those changes before they go into effect. It's called pre-clearance. They have to pre-clear any law passed by the legislatures of any one of these states before it can go into effect. And Mississippi is one of these states covered by Section 5 of the Voting Rights Act. The Voting Rights Act has been passed several times since then. It was set to expire, I think it was 5 years after it first went into effect. Then it was extended for another 5 years. Then it was extended for 25 years. And then recently, I think in 2007 or so, it was passed for another 25 years. And it was unanimously passed in the United States Senate. Since that time, there was a challenge brought, actually the case before the United States Supreme Court now came out of Shelby County in Alabama. And what they have said is that this is not fair. It's not constitutional to just pick on these few states, which is covered by Section 5 of the Voting Rights Act. We're going to challenge the constitutionality of Section 5 of the Voting Rights Act, because if a law is passed, it should apply to all states, or it shouldn't apply to any, but just picking out these few states is just not fair. And that's what the Supreme Court is deciding right now, whether or not Section 5 of the Voting Rights Act is actually constitutional. And if you've kept up with it, it looks as though from the questions at the Supreme Court during argument, it's going to be a pretty close vote. Some are saying it's probably going to be a 5-4 decision. And but then again, nobody really knows what the Supreme Court's going to do. But to change the Voting Rights Act would be a very, very dramatic and very huge ruling at this point. So everybody's watching that kind of closely. The rest of the act would still remain in effect. They're simply challenging Section 5 of the Voting Rights Act, which is applied to just these few states and some counties and cities that have had a history of voting problems. When you look at ways to sort of fix the problem that Shelby County, Alabama, and others are complaining about, one of the solutions would be to have everybody affected by the same law. And do you extend Section 5 to the entire country, or do you decide that, yes, Congress has the ability to actually select certain areas? If you look at the act, I mean, it's in the Constitution. The Constitution says that Congress has the authority to regulate this area, and so if you just look at the broad wording of the Constitution, it appears that they may have the ability to do exactly what they have done. So it's going to be an interesting question for the Supreme Court. My guess is that it's going to be close. I would think it's probably going to be a 5-4 decision, one way or the other.